Hello friends, my name is Amit Jyoti. I am working as an assistant professor with the O.P. Jindal Global University. In this module, we shall be discussing the general principles of law. As discussed previously, the general principles of law recognized by civilized nations primarily mean general principles of law that are recognized by a legal system of different countries. Now, the question arises, why recognize them as a formal source of international law? Well, the answer to this lies in the fact that international law, and to be specific here, international human rights law is susceptible to gaps. The international legal regime lacks a supreme legislative authority, suffers from imperfect law-making procedures, and often relies on broadly defined laws that are more akin to standards rather than rules. Accordingly, no system of law can consist solely of specific rules covering every situation that could possibly arise. Unforeseen cases are bound to be encountered, and in that case, the judge would have to exercise his discretion and adjudicate a case on the basis of general principles of law which are recognized by a majority of nations around the world. Now, we shall explore the historical background of this principle. Article 38 of the Statute of the International Court of Justice has been borrowed from the Statute of the Old Permanent Court of International Justice, referred to as PCIJ. Now, within the Advisory Committee of Jurists interested with the drafting of the statute of the PCIJ, there was a lot of debate pertaining to the material content of the general principles of law as a formal source of international law. Originally, one of the proposals was to incorporate the wording, that is, the rule of international law as recognized by the legal conscience of civilized nations. After a lot of debate, this was however changed to the general principles of law recognized by civilized nations as it stands today. Now, prior to the adoption of how the provision stands today, President Edward Descamps, one of the members of the Advisory Committee of the jurists, eloquently defended his view of the existence of an objective justice in the following manner. He stated, "Concerning Mr. Root's statement that the principles of justice varied from country to country, that might be partly true as to certain rules of secondary importance, but it is no longer true when it concerns the fundamental law of justice and injustice deeply engraved on the heart of every human being, and which is given its highest and most authoritative expression in the legal conscience of civilized nations." The President here added that far from giving too much liberty to the judges, it would impose on judges a duty which would prevent them from relying too much on their own substantive opinion. It would be incumbent on them to consider whether the dictates of their conscience were in agreement with the conception of justice of civilized nation. Few other members of the committee also supported the express reference to general principles so as to satisfy a need of the judge in order to base his sentences on in the absence of a rule not being governed by a treaty or a custom. From the foregoing observations, it wouldn't be wrong to conclude that the members of the committee were concerned that in the future the court might be faced with a situation where neither a treaty provision nor a customary rule of law or was applicable. Accordingly, it was thought undesirable and possibly inappropriate in principle that the court should be obliged to declare what is known as non-liquid. This is a judicial finding that a particular claim can neither be upheld nor rejected for lack of any existing applicable rule of law. Therefore, it could reasonably be presumed that the concept of general principles was thought to fill the gaps in the existing law. Now, let's go on to the year 1945. At the time of adoption of the Statute of ICJ, it was agreed by the participating delegations that the corresponding Article 38 of the new statute would not undergo a general revision and would be incorporated as such from PCIJ. However, the Article 38 of the Statute of ICJ opened with the words, "The court whose function is to decide in accordance with international law, such dispute as are submitted to it shall apply." Now, let's look at the importance of the source, which is the general principles to human rights. It is now clear from our discussion that general principles were added as a formal source of law to fill the gaps. However, in the field of human rights, these general principles have played a significant role in the development of jurisprudence. Here are some reasons as to why general principles have created a space for themselves in the realm of human rights jurisprudence. 1. We are far from having achieved a universal ratification of all human rights treaties. In fact, given the number of regional treaties and agreements cropping up at all the times, the regime for international human rights has become more and more fragmented and to some extent conflicting. This necessitates the existence of some universal general principles to which all states should abide by. Secondly, as I have stated previously, there are times when a state at the time of expressing its consent to be bound by a treaty also expresses its reservation to certain provisions laid down therein. This possibly could only be circumvented by recognizing a universal principle to which all nations must adhere to. Third reason, it is increasingly recognized that states are not the only subjects of international human rights law. As subjects of international law, international organizations are bound by general international law. And some authors believe this could be extended to transnational corporations as well. Therefore, in order to impose human rights obligations on such private non-state actors, these obligations must have their source elsewhere than in treaties which as a rule only states may ratify and not non-state parties. Now the next question is how to discover whether something is a general principle of law. The International Court of Justice has also resorted to general principles of law in judgments and advisory opinions. However, on all those occasions, it did not always clarify that it were applying Article 38, Para 1C of its statute. The court, it must be admitted, has shown restraint in its recourse to general principles as authority for its pronouncements. Even when relying on general principles of law, the court has not infrequently either referred also to customary international law or left it ambiguous as to whether it was speaking of a general principle or some other rule. For that reason, and given that both customary rules and the general principles of law are unwritten legal norms, it is sometimes difficult to ascertain whether the International Court of Justice applied the former or the latter. Yet, it is possible to discover general principles of law in the judgments by taking into account some signs of their application. Let's take an example. Use of particular terms such as established principle or general concept of law or fundamental principles or well recognized principles or let's say essential principle or principles generally accepted or well known rule, among other phrases which the court might refer to in its judgments and opinions. The question that now arises is that what basic conditions must be satisfied before a principle qualifies to be considered a general principle of law recognized by civilized nations. Given the number of independent states over the past decades has increased to almost 200, does this mean that today a general principle has to pass a test of 100 legal systems before it could be construed as a general principle of law recognized by civilized nations? Possibly not. It was never intended under para C of article 38(1) of the ICJ that proof should be furnished of the manifestation of a principle in every known legal system considered to be civilized. And certainly it has never been the practice of the ICJ or other tribunals to insist upon proof of widespread manifestations of a principle or to indulge in elaborate comparative study of legal systems of the world. Now, in this regard, it is to be noted that ICJ, in pronouncing its judgments, does refer to general principles of law to settle the cases at issue, but it does so without elaborating further on such principles. In fact, there is hardly any instance where the ICJ has delved deep into an analysis of law to extract a general principle of law. However, as matter of generality, it appears that given Article 38 para 1c of the ICJ statute does not refer to general principles of international law, but to general principles of law. General principles of law would be legal provisions common to national legal systems or prevalent in international law. Accordingly, the courts may either have recourse to decisions of international courts, tribunals, or a comparative research to determine if a given principle is a general principle of law. This latter study could possibly involve the study of legal rules from national systems to begin with, and thereafter making sure that such derived principle is generally recognized by nations. If a good majority of the nations recognize a particular principle, it could be argued that it is a general principle of law recognized by civilized nations. This assessment, however, is subjective and totally at the discretion of the court the matter is before. Now, next we shall discuss that how ICJ has taken recourse to general principle of international law. The ICJ often takes recourse to general principles in the realm of human rights. However, matters dealing with human rights violations have usually formed a small part of this docket. Nevertheless, here are a few observations that were made by the International Court of Justice in invoking the general principles clauses in its statute. The first being in the Curfew Channel case, that was a case between the United Kingdom of Great Britain versus the People's Republic of Albania. Here the court observed the obligations incumbent upon Albanian authorities consisted in notifying, for the benefit of shipping in general, the existence of a minefield in Albanian territorial waters and in warning the approaching British warships of the imminent danger to which the minefield exposed them. Such obligations are based on certain general and well recognized principles, which are elementary considerations of humanity, even more exacting in peace than in war. This case arose out of an incident that occurred in the Albanian territorial waters of the Corfu Channel, where two British warships were struck by mines and therefore incurred heavy damage and loss to human life. In another advisory opinion on the matter of the reservations to the Convention on the Prevention and Punishment of the Crime of Genocide, the ICJ held that the origins of the Convention show that it was the intention of the United Nations to condemn and punish genocide as a crime under international law involving a denial of the right of existence of entire human groups, a denial which shocks the conscience of mankind and results in great losses to humanity, and which is contrary to moral law and to the spirit and aims of the United Nations. The first consequence arising from this conception is that the principles that underlie the conventions are principles which are recognized by civilized nations as binding on states even without any conventional obligation. The Genocide Convention was therefore intended by the General Assembly and by the contracting parties to be definitely universal in its scope. This is what the ICJ had stated in its advisory opinion. Now, this was a matter which was referred to the ICJ for its advisory opinion by the General Assembly of the United Nations. The basic idea of this advisory opinion was to pinpoint the effect of a reservation that is put in by a state at the time of expressing consent to be bound by the Convention on the Prevention and Punishment of the Crime of Genocide. In another case concerning Barcelona Traction Light and Power Company Limited, which was a case between Belgium and Spain, the ICJ observed, by their very nature, the obligations of a state towards the international community as a whole are the concern of all states. In view of the importance of the rights involved, all states can be held to have a legal interest in their protection. Their obligations erga omnes. Such obligations derive, for example, in contemporary international law from the outlawing of acts or aggression and of genocide, as also from the principles and rules concerning the basic rights of the human person, including protection from slavery and racial discrimination. Some of the corresponding rights of protection have entered into the body of general law. Others are conferred by international instruments of a universal or a quasi-universal character. in the United States diplomatic and consular staff in Tehran, which was a case between United States versus Iran, the International Court of Justice observed, wrongfully to deprive human beings of their freedom and to subject them to physical constraint in conditions of hardships is in itself manifestly incompatible with the principles of the Charter of the United Nations, as well as with the fundamental principles enunciated in the Universal Declaration of Human Rights. Now, this case was brought to the ICJ by the United States of America against Iran in response to the Iran hostage crisis. In this crisis, the United States diplomatic offices and personnel were seized by militant revolutionaries. In the case concerning military and paramilitary activities in and against Nicaragua, which is a case between Nicaragua versus the United States of America, the ICJ held that the court considers that there is an obligation on the United States government in terms of Article 1 of the Geneva Conventions to respect the conventions and even to ensure respect for them in all circumstances, since such an obligation does not derive only from the conventions themselves but from the general principles of humanitarian law to which conventions merely give specific expression. Now, this was the case that was brought to the ICJ by Nicaragua, alleging that the United States was encouraging, supporting and aiding direct military and paramilitary actions in and against Nicaragua. In another case concerning East Timor, which was a case between Portugal and Australia, it was held by the ICJ that in its view, the right of people to self-determination as it evolved from the Charter and from the United Nations practice has an erga omnes character, is irreproachable. The principle of self-determination of people is one of the essential principles of contemporary international law. In this case, Portugal, the administering power for the territory of East Timor, instituted proceedings against Australia, alleging that by its conduct it had failed to observe the right of people of East Timor to self-determination and other related rights that belong to the people in this territory. In the advisory opinion on the legality of threat or use of nuclear weapons, the court held it is undoubtedly because of great many rules of humanitarian law applicable in armed conflict are so fundamental to the respect of the human person and elementary considerations of humanity, as the court put in its judgment of 9th April 1949 in the Curfew Channel case, that the Hague and Geneva Conventions have enjoyed a broad accession. Further, these fundamental rules are to be observed by all states whether or not they have ratified the conventions that contain them. The reason is because they constitute intransgressible principles of international customary law. Now, this case came about when a large group of non-nuclear countries took the initiative of asking the ICJ for an advisory opinion on the legality of the threat or use of nuclear weapons. Thank you for listening to this module.